A will force your assets to go through the probate process. The reason being is that any assets listed on that will are still going to be in your personal name. And any assets in your personal name when you pass away will have to go through the probate courts to be distributed out to the beneficiaries listed on that will. If you want to avoid the probate process, we have a couple different options depending on the types of assets that you have. For real estate, you can do joint tenancy right to survivorship or a transfer on death deed. For your financial accounts like checking, savings, and investments, you could jointly own those with your spouse or your children, or you could set them as designated beneficiaries on those accounts. For your retirement and life insurance policies, you can name designated beneficiaries on those accounts as well, but you will have to hold retirement accounts in your personal name. If you want to account for everything in one location, you can set up a revocable trust, transfer all of your assets into that revocable trust, or name that revocable trust as a designated beneficiary on your financial accounts. That way, everything will either be inside your revocable trust or go into your revocable trust when you pass away, and then you can either distribute those assets out to your beneficiaries and avoid the probate courts altogether, or you can keep them inside that revocable trust and control distribution. That way you're not exposing those assets to your children's or your beneficiaries' liabilities, like divorce settlements, lawsuits, or creditors coming after them, or you're mitigating the risk of them blowing that money if they are bad at managing their own money. If you want help setting any of this up, click the link in the bio, fill out the form, and schedule a time to talk to some more of our team.